Welcome to ThePrint. Apart from all the usual reasons for which this country is obsessed with marriages, marriage has specially been the flavor of this season for the past month or so. This was after the debate and discussions around marriages reached the Supreme Court with the marriage equality petitions. And the focus of this debate and these discussions have largely been this one law. It's called the Special Marriage Act 1954, and this is the law that we'll be talking about today in today's episode of Laws of the Land. For this episode, once again, you have me, Apoorva Mandhani. We have with us Bhadra Sinha, and we have with us Supreme Court lawyer Nipun Saxena. Thank you so much for joining us,
Thank
Nipun.
you. It's such a pleasure.
It is actually, a pleasure to have you, Nipun. In fact, we must tell our viewers that it was on Nipun's petition. In fact, if you Google Nipun Saxena, you will come across this judgment, which is titled Nipun Saxena versus Union of India. And it was on Nipun's petition that the Supreme Court laid down extensive guidelines to protect the identity of sexual assault victims, which also include minor victims, right? So, Nipun, before we talk about why the Special Marriage Act is right now in the news and why marriage is the flavor of the season, as just told by Apoorva, we would just like to first start with a brief history around the Special Marriage Act for the viewers to make them understand what the law is all about.
Right. So the conspectus within which Special Marriage Act operates applies to individuals who do not belong to a particular caste or creed or religion or even nationality for that matter, so long as one of them may be of Indian origin. That's the only fundamental prerequisite for the purpose of registration of marriage under the Special Marriage Act. Now, of course, traditionally speaking, Indian society in the British era or even during the British era was one which conformed with the idea of caste. They did not want to, in fact, marrying outside caste was frowned upon. So in the year 1870s, when the British decided to overhaul the entire legal regime, there were two big scholars of the time. One of them was H.S. Maine, who decided to bring about a change in the personal law system. He proposed that it doesn't make sense for people to not marry outside caste because to the democratic society as prevailed at that point of time, it's an anathema.
Right.
So he said that, all right, instead of tinkering with the personal laws, namely, say, just to give you an illustration, Hindus will have a prohibited degree of marriage, or saying marrying outside of their sapinda, right, or religiously in some castes following the Gotra system only.
Okay.
So Maine decided that let's get out of all of this and create a special statute. Now that was brought about in the year 1872 by making an amendment to the civil law at that point of time. There was an
During the
act
British time.
during the British time in
Okay.
1872 itself. Now, from 1872 till the time India gained independence, that was the law under which marriages were registered, where people wanted to marry individuals outside of their caste, creed, or religion.
Right.
But the element of extraterritoriality was not there, which is
Okay.
to say that if a person in India wishes to marry a person from abroad,
A foreigner.
then that particular kind of a relationship could not be given the sanctity of marriage. And therefore, in the year 1947, of course, when India gained independence, in 1954, they thought that we must come out with a legislation to even address this contingency. Even at that point of time, the legislators were conscious that they must not tinker with the personal laws, which are applicable to, let's say, Hindus inter se, or Muslims inter se, or Parsis, or Christians. Therefore, they brought in this current legislation, which goes by the name of Special Marriage Act, which provides for a marriage between people who may have a different faith, may profess a different religion, may come from a different caste or a creed. Or in fact, now as the definition stands, they may not necessarily also be Indians, so long as they are Indian origins, living in different countries. So that briefly is the history.
So does it mean that if somebody is a member of the Hindu community, say two people are the members of the Hindu community, can they get married under the Special Marriage Act? Of course, the Hindu personal law would be applicable on them. They have a choice to get married under the Hindu Marriage Act as well. But does the Special Marriage Act permit such individuals also to get married?
Of course, it does. There's no fetter on two Hindus deciding to marry under the Special Marriages Act. But Bhadra, this question the answer will have slight nuances. Say, for instance, let's take it one step further. A person lives in a joint family and he decides to marry somebody from the same faith, but under the Special Marriage Act. Now, the difficulty begins because succession and all those laws will continue to govern under the Hindu Succession Act only.
Okay. So that's now the next question is that if you want to get married under the Special Marriage Act, do you need to sever yourself from the personal law?
So, in fact, there are two responses to it. The first is Section 19 itself of the Special Marriage Act. It clearly says that in case a Hindu marries outside of his religion, which is of course
which would be an interreligious
marriage, then he is deemed to have severed his relationship as part of the joint Hindu family.
Okay.
However, there is also Section 23 which saves such marriages provided a Hindu is marrying a Hindu.
Okay.
So in that case, the prohibitions which are contained in Section 21 will not be attracted.
Okay, so which means that if you get married under the Special Marriage Act, then you need not, as you mentioned, unlike in the case of an interreligious marriage, you need not sever your ties.
That's right.
From the personal.
Absolutely. Right. So you continue to remain part of the joint Hindu family, continue to derive benefits out of the joint family property, namely succession or whatever, and at the same time continue to have a registration under a different
which is the Special Marriage
Which is the Special Marriage Act.
So then it would be correct to say that the Special Marriage Act actually provided an alternative legal remedy to to couples, to interfaith couples, or to couples who believed in intercaste marriages, or to couples, as you said, who where one of the partners is a foreigner and the other is an Indian. So it was like an alternative legal remedy provided to them.
That's right.
But why do we need an alternative legal remedy? If you could just explain that as well.
Well, an alternate legal remedy was required for the simple reason that there are far too many faiths even within the umbrella definition of a Hindu.
Okay.
If you look at Hindu Marriage Act, the manner in which Hindu is defined would include even Sikhs, Jains, Buddhists, etc. Now, somebody within Buddhism may have some sort of a social fetter or a communal fetter in their own sense to not marry, say, Mahayana.
Okay.
A Hinayana may say, I don't want to marry a Mahayana.
Okay.
Because, say, one part of my communion says to the contrary. Therefore, to address all these aspects, Special Marriage Act was created. So even within, or let's say, just to give you another example, Gotras, same Gotras, there may be a prohibition under a specific legislation, namely the Hindu Marriage Act, if at all, because it also recognizes any of the specific tradition or ritual which are observed by that particular caste.
Okay.
Now that may be a fetter there,
Okay.
but it will not be a fetter under the Special Marriage Act. So you can marry under the Special Marriage Act.
Okay.
Right? However, even to that extent, Section 4 of the Special Marriage Act protects, say for instance, a person cannot marry within prohibited degrees of relationship, right? But let's say in a particular community, let's say a religious community, in Muslims, for instance, if there is a person where it's traditionally in their own religion, it is such form of marriages are
allowed.
permissible.
Yeah.
Then such forms of marriages are also saved under the Special Marriages Act.
Okay. Okay.
So that's something
So
which
it's
is
providing
peculiar.
multiple remedies. this
Absolutely.
means.
In fact, so many people who are, may I say, more educated, or who may have a lot of, who have a better understanding of the law, prefer to get married under the Special Marriages Act rather than traditional
Right. And
legislations.
when they prefer to get married under this act, now for our viewers, could you please explain what the procedure is like, how different it is from other personal laws, and how does one begin doing that
Yes.
getting married under the Special Marriage Act?
All right. So I think it all begins with a form of an intimation.
Okay.
Two people who want to marry will give an intimation to the registrar.
Hmm.
Now, this person, I won't call him the registrar because he performs different features. Under the law, he is defined as a marriage officer.
Okay.
So, first, you intimate the marriage officer. The marriage officer and both parties must convey that intimation that, of course, two people. The marriage officer will first see whether the conditions of Section 4 are met. What are those conditions? Namely, that there must not be a disability. Now, what is that disability? That disability is both people must be of marriageable age. Namely, the man is 21 years of age and the woman is 18 years of age. Both individuals are sane, does not suffer from unsoundness of mind. Both of them have been residing in the place, or one of them has been residing in the place 30 days before presenting the notice.
Okay.
That's a fundamental criteria.
And
now,
it has to be a joint intimation by the couple, or
yes,
either one
or
of
either
them?
one of them can
Okay.
commence.
Okay.
The other person has to give a declaration. On the
Okay.
spot. Now, of course, after having received it, he will call upon objections, and he gives a 1 month period, asking anybody who has a problem before these guys go ahead and say, I do.
And anybody can object.
And anybody can object. However, the grounds of objection are limited to Section 4.
Okay. And
Which those objections are that, of course, that person has already married somebody else during their lifetime, or that person is living in a bigamous marriage,
Okay.
or that person is not mentally sound in terms of the definition,
Okay.
or that the person has been convicted for an offense more than 7 years, because that also happens to be a ground, interestingly, under the Special Marriage Act.
Okay.
Right? Or that the person was not known for 7 years and therefore he was proclaimed dead in the eyes of law, and then suddenly he comes up and contracts a different marriage.
Okay.
So those things, those objections are the ones on the basis of which somebody can raise that objection. Of course, the marriage officer thereafter will consider, if objections have been received within 30 days, whether those objections have any substance. If he comes to a different conclusion, then the marriage officer will go ahead and proceed to issue a certificate under Section 13 of the Special Marriage Act. Once the certificate is there, both parties, of course, there's one more step in the middle. Before issuance of that certificate of marriage, both the parties would be called upon by the marriage officer. They have to provide their respective declarations. There are 3 witnesses who have to attest that we know these 2 individuals, we know that these people want to today decide to take their respective vows. And thereafter, the registrar will request them to get married in a manner they want to get married.
That is the couple.
That's the couple.
I see. Okay.
So, whatever faith you may profess,
I see.
you want to sign it out, you want to exchange vows, you want to put a garland on each other's neck, you want to carry out Saptapadi, it's your choice.
And is that supposed to happen in the presence of the marriage officer, or it
Not
can happen
necessarily.
anywhere?
The 3 witnesses have to only attest that we saw these
The marriage
the
too.
marriage ceremony
No other
taking
evidence
place.
needs to be given,
absolutely
nothing.
whatsoever. And if you submit all of those, of course, it also depends upon the satisfaction. Now, let's say the marriage officer says, I don't believe, give me photographic evidence. Then you naturally put all of those. But assuming there is no hanky-panky there, everything is going smoothly, then naturally the marriage officer will proceed to register, take their declarations under Schedule 4 and decide to issue a certificate to that effect. And for all intents and purposes, this will be an evidence of a proper marriage.
And what if the marriage officer decides not to grant them a
Yes.
marriage
Now,
certificate?
in such a situation, if the marriage officer comes to a contrary finding, then you can always challenge the finding of the marriage officer by filing a petition, an appellate petition, before a district court, which usually is the family court of the particular jurisdiction.
Okay, so there is a proper judicial process which can be
Absolutely.
resorted to later. Now, tell me one thing: does the Special Marriage Act also deal with something like divorce, or is it only regarding marriage?
Of course, it deals with divorce, it deals with alimony, it deals with maintenance. It's a complete code.
It's a complete code in itself. Okay.
Divorce, again, those grounds, mental cruelty and desertion,
All those
all those grounds, venereal diseases, being held guilty of an offense
Okay.
for an offense exceeding 7 years
Those
are
are
on
the
those
same.
grounds.
They are
So
the
there are
same.
many in nature, and of course, depending upon which ground is to be invoked, that petition, just like any other petition, can be filed before the family court or jurisdiction.
So Nipun, we talked about this particular provision which requires the magistrate, the marriage officer to give a 1 month notice period.
That's right.
Now this is quite under debate. Many
Yeah.
people have questioned it. Some have filed petitions around it as well. Could you just explain the reason and the cause of behind such petitions?
Right. I think since some of them are sub judice, I will only go
Yeah,
on the
we are just
principle.
yes,
Right.
of course.
Right. So I think that the rationale is that if there are two consenting individuals and if they do happen to meet all the other qualifications as are prescribed under Section 4, then there is no reason or business for anybody else to object. Now, of course, they draw strength from Justice Puttaswamy's judgment saying right of choice. Choice means individual of your choice. If you want to marry that person, and if that relationship itself is a facet of Article 21, then it must be given its complete scope and meaning. Then you can't have these procedural infirmities calling into question your proper exercise to right of choice itself.
Right.
Now, of course, a contrary argument which is being given is that please look at the objections and the nature of the objection. It's not like anybody will come up and say, sorry, I am the father and I am not consenting.
Okay.
Those, of course, are, deservedly must go to the dustbin, those petitions.
Okay.
But those set of petitions which take legitimate grounds, namely that this person was not even here. For 7 years, he was declared to be dead. And now he just surfaces out of somewhere and decides to contract another marriage. Or let's say in case of another person where there was already a living spouse and he contracts another marriage.
Yeah.
Then what happens? So therefore, in order to even address those contingencies, the Special Marriage Act has provisions for voidable marriages and void marriages.
Achha, so the provisions are already there.
Already
this
there.
means. Okay.
So to my mind, save and accept those legitimate grievances.
Yeah.
The right of choice is adequately manifested in the form of specific safeguards contained in the provision itself.
Because of course, as you mentioned, this law was primarily brought in to support interfaith marriages. But many interfaith couples have complained about, this 1 month notice period. And that is probably one of the reasons that they have to resort to another form of marriage. I don't want to name it because it can be easily, done with the help of certain pundits. And another area of concern is that the discretionary power which is vested with the magistrate, with the marriage counselor, because it can be subject to it can be subject to misuse. It can be used to harass couples as well, because we have come across instances. So what do you, say around this?
Well, you're right, Bhadra. When it comes to a requirement of the marriage officers, which is, like I said, their satisfaction is on the basis of their discretion. Now, discretion must be guided by principles of law, but many a times it is not. That's the unfortunate reality. Many marriage officers call upon an additional onus, or they cast an additional onus on the couples to call for their parents' consent. Now, that is not required under the law.
Okay.
Which is one of the primary reasons why they object. That most of the marriages, let's say, may happen because the parents are not agreeing.
Okay.
But that does not take away the fact that two people want to be with each other.
Okay.
And the law does not
Okay.
impose any fetters.
Okay.
But it's the marriage officer who is imposing those fetters. And therefore, they want to do away with the concept of objection altogether.
Okay.
They say, na rahegi baans, na bajegi bansuri, which is basically...
Does the concept of objection or 1 month notice exist under any other procedure for marriage, under any other personal law?
Well, it's interestingly not there. But here, since they are also taking, because I'll tell you why it is not there, because any person who is aggrieved at any point of time can always file a petition for declaring it as void.
Oh.
So let's say, for instance, Section 11 in the Hindu Marriage Act is a particular provision which you can use. But this particular requirement, you are very right in saying that it's not available in any other law, which seems to be a problem. So now many people are saying that this is also an Article 14 violation, because let's say those people who you are applying to different standards to do different registration processes.
Right. Yeah.
Now, that is a very strong argument in favor of the petitioners.
Yeah.
But the fact remains that I think the reason why that objection system is there in place is also because they are dealing with not just interfaith but also inter-country issues. So
Okay.
now let's say a marriage officer who is deployed in Chicago will not know what happens to a person who is residing in Hamburg, Germany. And by the time they have to go by the face value of whatever documents are presented. Now, of course, another counter argument to what I have just said is that somebody may at any point of time make a petition as and when they come to know that this particular process was not done or that it was done on the basis of false documents being submitted. Then you can always revoke it. You can still use those voidable marriage arguments. But those documents are not part of public scrutiny. So you don't ever know.
So you don't ever get to know. Yeah.
Which I think is the basis why they will have this sort of a procedure in place.
I have one question. If a couple gets married under the Special Marriage Act, can they seek divorce under their personal law? Is it possible?
No,
especially in a case where it may not be an interfaith marriage, where a couple belongs to the same community.
That's right.
Yeah.
No, I don't think that happens.
Okay.
And the reason is very simple. Special marriage, if two people are marrying under Special Marriage Act, they can only get divorced under the Special Marriage Act.
Okay, it's very clear.
Every other thing, which is to say your benefits under the Hindu Marriage and Succession or Hindu Succession Act, etc., will continue to flow because there's a deeming fiction created in the Act itself.
Yeah.
But barring that particular deeming fiction, there is absolutely no justification for seeking divorce under a different act altogether.
Okay, Nipun, now tell us, why is this law being debated in the Supreme Court? What is this whole thing about?
Well, the same-sex marriage petitions, which have all been preferred before the Supreme Court, want it to be recognized as a right for a union between two individuals having same sexual orientation, and that particular union to be given the status of marriage. Declaration of a union, and that declaration to be in the form of a marriage is what some of these petitions are seeking.
Within the Special Marriage
within the
Act.
framework
Within
of
the framework.
Special Marriage Act. Now, of course, many of the petitioners do realize that we cannot tinker with the personal laws at this point of time. So let's take one step at a time. Let's first seek that declaration under the Special Marriage Act. And since the Special Marriage Act in Section 4 uses persons instead of man or a woman, therefore
two persons getting married.
So that person could be given
any sexual
orientation. And therefore, in principle, they argue that Special Marriage Act in fact recognizes this, but you have to tweak it a little. Now, of course, the argument from the opposite side, only on merits, which I feel is the only argument on merits, is that amend what and how many provisions.
Okay.
You say Section 2B, which is the foundational definition clause, defines a man to be only a biological man. This is how they define it.
Of the Special Marriage Act.
Of the Special Marriage Act. And they say that the prohibited degrees of marriage, namely a man marrying his own mother, a man marrying his own sister, are all mentioned in the schedule. There are 37.
Man and woman.
Man and woman. And therefore, man is defined and woman is defined.
In the Special Marriage Act.
In the Special Marriage Act itself. And therefore, if you have to amend, you will have to get rid of the entire act itself, because it's elementary principle of law that if you are challenging a statute and there is a problem in the definition itself, the primary definition, then the entire statute has to go. Because that same man and woman will keep coming on. Just to give another illustration, while person continues to be in the definition of Section 4, man and woman are used interchangeably under sections 36, 37, 38, which deal with maintenance, alimony.
Okay.
Because there they say only a woman is entitled, only a wife. Now a wife, let's say in case of a gay couple, who will be the wife is the question, because they don't satisfy the definitional requirement. Now if somebody does not want to claim maintenance, that's great. But in the eventuality that somebody wants to claim maintenance, there's going to be an obvious problem. The workability of the statute itself.
Okay.
So there are as many as 18 places where the amendments will have to be carried out, which the respondent is arguing before the Supreme Court is not the function of the courts. The court can either strike down a legislation in its entirety, or the court can sort of request, because it can't even direct the parliament to make a law on a particular subject. So an interim arrangement which comes to my mind would be setting up a high-powered committee to look into the merits.
And make suggestions.
But it's interesting to point out that in the United Kingdom, let's say, they have a specific format. They don't deal with, because of course there's a separation of church and the state. So the UK came out with a new system. They said, let's call it civil partnership.
Okay.
Right.
And let's devise a unique system in place, give them all the benefits that may emanate otherwise, and let this civil partnership be recognized for all intents and purposes.
But that would also mean to have a separate law.
That would mean so. Now, the UK Parliament was quick to do it.
That's right. Yeah.
Now the question is, can the Indian Parliament walk the talk? If they do decide to make that statement, that we will bring out a legislation.
With this, on that note, we've reached the end of this episode. In this episode, we discussed how and why and what was the need of a law like the Special Marriage Act, and that too so early after the independence of the country. The law was brought in as a promise to the citizens to allow them to marry interfaith and provide them with a separate legislation and a code altogether to enable them to do so. Now, at the stage that we've reached, like I mentioned at the start of this episode, the debate around the law has reached the Supreme Court. So, whatever side it leans on, it would be a step that would impact how we view marriages altogether. Thank you so much for joining us. Hope you like this episode. Like I always say, please do let us know in the comment section if you want us to take a law, if there's a law that you'd want us to discuss, and if there's an expert that you want to listen to. Thank you so much, and do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.